Good evening, everyone. I'm delighted to welcome you to our insightful YouTube class on data protection concerns and commercial agreements. Today, we will attempt to explore the intricacies of safeguarding sensitive information in business transactions and provide our joinees with valuable insights on navigating privacy issues while drafting commercial agreements. I'm excited to be a part of this class where we will try to enhance your legal knowledge and help you stay ahead of the evolving landscape of data protection. To this end, I am honored to be welcoming Ms. Anna Klein, who is an attorney of law at Marseille and New York Bar, a distinguished attorney currently with her own practice. Ms. Klein has previously been associated with multiple prestigious firms in France and New York. She is also a graduate of A. Marseille University, following which she pursued her LLM from New York University School of Law. I'm certain her insights today will be valuable contributions to our legal learnings. Thank you so much for being here, ma'am. We really appreciate this.
Thank you. So I will start by sharing my screen. Mm-mm-mm. Oh. Yes, this one. All right. Can you see correctly my
Yes,
screen?
ma'am, it's visible now.
Great. Just making sure. Um, so thank you very much for the introduction. So my practice is focused on mainly three aspects: intellectual property, data protection, and commercial agreements. So the first aspect is a little outside the scope today, but actually today is a very interesting topic because we are going to try to connect data protection and commercial agreements. And actually, there are a lot of attorneys who practice commercial law and draft commercial agreements every day. But among those attorneys, not many of them um, also practice data protection and consider that as a separate issue. But actually, there are so many interactions. And the point of this lecture today is to show you that whenever you are drafting a commercial agreement, you should always have some data protection concern in your mind, and either you are competent to tackle them yourself, in which case it's great. If not, you should always try to reach out to an attorney who also practice in data protection. I actually had this conversation with several of my colleague attorneys who regularly practice commercial law, and they were wondering how could they recommend my my services, and I was quite surprised actually that they didn't realize how many interactions there are, and they are drafting commercial agreements every day without really considering the data protection aspects. So let's begin with a brief reminder of what is a personal data, because obviously when we're talking about data protection, we're not talking about any kind of data, we're talking about personal data. And it's important to understand what it is exactly, so that's the first step to identify when there might be an issue or not. And an issue doesn't mean that you're not going to be able to carry on the business that you intended. It just means that you need to address the fact that there is some data processing. So personal data can be many things. The easiest way for me to describe it is with the definition of GDPR. So obviously, as you know, I'm an attorney in France as well as in the New York bar, but my practice is mainly in France. So my main reference for data protection regulation is GDPR. Obviously, nowadays there are many other regulation, but still GDPR is the the first big binding reference, and it kind of became a worldwide standard. So, personal data means, and I'm quoting again GDPR, any information relating to an identified or identifiable natural person. So, the first information that we have right here is that it has to be a natural person. So, whenever the information relates to a company or any other moral entity, then it is not personal data. But you shouldn't be mistaken. It's not because it's business information that it's never personal data. Actually, many business information are also personal data. For instance, an email address. Indeed, if the email address is not connected to any particular individual, then it's just connected to that business, then it's not a personal data. But if an email address is my email address within this company, then it absolutely is a personal data. So you shouldn't be mistaken by thinking, oh, but that's just my professional address. So it's not a personal data. It is still a personal data. Same goes with phone numbers. A phone number, of course, if it's your personal line, it's a personal data. But if it's your personal line at the company that you're working at, then it's also a personal data. On the other hand, if it's a phone number that's not it's not a direct line to anyone, then it may not be a personal data. Same goes, of course, with addresses, postal address. Oftentimes, for small companies, the address of the company sometimes also relates to the home address of the legal representative of that business. So keep an open mind, and whenever it might be connected to an individual and not just to an entity, it is a personal data. But then the other difficult aspect to grasp when it is a personal data or not is that we're talking about an information relating to an identify or identifiable natural person. So, of course, if I'm saying my name is Anna Klein and this is my phone number or my email address, then it is obviously a personal data. But if I'm giving you just a phone number and you don't know whose phone number it is, so the person is not identified, but it is still considered to be a personal data because it relates to an individual and indirectly this person could be identified. So this is the definition of an identifiable natural person, is one who can be identified directly or indirectly. And the indirectly part is really broad again. So here they give us a number of examples, such as a reference to an identifier, such as a name, an identification number, location data, online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. So, for instance, if I'm giving you an income, like a given person earns, I don't know, $100,000 per year. This would be an economic information, or as well as social information. And you don't know who that person is, but you're not saying this information. It depends if I'm giving it as a broad example, or if I'm speaking about the income about someone. And even though I'm not telling you the name of that person, I'm still talking about one specific person's income, not just anyone's income, this person's income. And you don't know who that is, but I'm still referring to this one person. So this would still be considered personal data. So don't think about, oh, but it's anonymous, etc., etc. This isn't sufficient to consider that it's not personal data. um, Other thing, like physical aspects, for example, the color of my hair. You 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 could argue that, and you would be absolutely right, that the color of my hair doesn't have anything special. I am confident that many, many, many other people on this planet have the exact same color of hair as I do. But still, again, if you're gathering this information referring to the color of my hair and not just saying, yeah, someone who's got brown hair, but like this person has brown hair, even though you don't necessarily also have my name next to this information, you're still collecting information about me. And if you crossed several information, for instance, the color of my hair itself would not be sufficient to identify me. But then if you add, I don't know, the place where I work, okay, this would, of course, uh, provide more information. But let's say that there are 50 person who work at the same place as I do. So among those 50 person, there are probably still several people who have pretty much the same hair color as me. So then, if you add more information, such as my age or my height, or the color of my eyes, and if you cross those information together, perhaps you would be able to identify me, because maybe there are, like, let's say we're 10 people with this exact same hair color, but only three of them who have the same size as me, and then among those three, only me who has this age. Anyway, I think you get the idea. So just think as broad as you can in terms of data protection. So the main example, obviously, are the name, the date of birth, address, email, phone number, but also some kind of ID, such as an administrative number, for instance, the number of my ID card or of my social security number. Like, if you see just a social security number, you wouldn't be able to know who does it relate to, but the state knows who does it relate to. So again, it would still be able to identify me indirectly. Or my credit card number, my bank information. And also in HR, you have also other type of data that is collected, such as evaluation, or your time schedule, or things like this. Also, consumption habits are also data, personal data, and IP address. Anyway, again, think as broad as possible. So when this is clear in your head, what is personal data? You may think, yeah, but I don't know, I'm signing lots of agreements where we don't use any of, we don't need to collect any specific data. I don't know if this is what you're thinking, but if this is what you're thinking, I'm going to say you are wrong. If you look mainly at the name, the address, the email, the phone number, it's practically impossible to have a commercial relationship without those information. So this is our main question today. When should we think about data protection when we're drafting a commercial agreement? So anytime that there is a data processing, and by that I mean a processing of personal data. So we know what is personal data. We just discussed this, but now what is processing? At what point do I consider that I'm processing the data? Very often, when I discuss this with my clients, the first response is, no, 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 but I'm not doing anything with the data. Like, yeah, of course, I know the name of my clients, but I'm not doing anything with it. I'm not sending it to anyone else. I'm not especially selling it. I'm not like they're just thinking of all the things that they're not doing. They're just basically trying to argue that the only things that they're doing is legitimate, and this is good. What they're doing is legitimate, but it doesn't mean that it's not processing. Even when you're absolutely right in doing what you're actually doing, it is still processing at the very moment when you just know any kind of data, even if you're not recording this data, even if you're not the one who collected it. Just the fact that you visualize some kind of information that happens to relate to a personal individual, then you're processing personal data. So it's just very easy. Whenever you're sending an email, you're processing personal data, unless if you're sending it to an address that's like uh, contact or info at nameofthecompany.com. If it's an info or a contact address, then again, it may not be a personal data. And I'm saying may. Sometimes it still is a personal data. If even what I'm saying is that it doesn't require to have the name of the person in the email address for it to be a personal data. It only requires that this address directly links to one individual. This individual is the only one using this address. So it's like a direct line, a direct address. Um, so I wrote down a few examples of what can be processing. So obviously, when I'm collecting data, even when I haven't done anything with it yet, I just collected it. The collect itself is already processing. The recording of personal data, of course, is processing, but there's lots of other things that we don't think as often, such as the simple use. Like I said, even if I don't record your phone number in my personal book or my contact book or in my phone, if I'm just dialing your number and calling, then I am processing personal data. Even if I'm just visualizing or consulting some personal data, it would be processing. And of course, there are the more dangerous, if I can say, type of processing, such as a transfer to a third party or cross-referencing of personal data, or if once I have the personal data, I am using it and organizing it, structuring it, conserving it, adapting it, modifying it, extracting some data to make it something else, or making it available to the public or to some specific individuals. All of this would be processing. So again, think as broad as possible. So do you really think that you can draft a commercial agreement without doing any of those things? Honestly, I don't think so. So I laid out 4 situations in which we are necessarily using personal data. So the first one is really easy. It's the one that we think of the most. But even when we think about it, we don't necessarily do what we should be doing. So during the execution of an agreement, I am going to use the personal data of my co-contractor, the person with who I signed a contract. So let's say that the person with who I signed a contract is a client. Let's say that this client is an individual. So it may be a regular contract, or it could also be general terms and conditions. You know that those have contractual value if they are accepted properly by the client. So either we have a regular kind of contract with both names of the parties, and it's personalized, let's say, or I have a package of general terms and conditions that applies to all my clients, and whenever they sign, whenever they place an order, for instance, then those conditions apply. Well, whichever form it take, then when I'm executing the contract, most of the time I'm going to use personal data. So let's take an easy example. Um, I am a company, an e-commerce company. I have a website and I'm selling stuff online. So whenever a client places an order to order, I don't know, anything, a pair of shoes or some makeup or a book or whatever, well, first I receive their order. So in the order, I'm going to have the name of the client. And then when I execute that order and I'm delivering the product that they order, I'm saying product, but it could just as easily be a service. We're clear on that. Whenever I have to make a delivery, I'm going to have to use personal data. So if it's a physical delivery for a product, obviously I'm going to use the delivery address. But even if it's a service, I'm going to have to use probably an email address so that I can provide the service, or a phone number or something so that I can provide my service to this client. Also, when I'm issuing an invoice, I'm going to have to write down some personal information about my clients. And maybe you're thinking, yes, but I only do B2B, so my clients are not individuals, and so I'm not using any personal data. Well, we will get to that later. I just want to first outline the different situation. So my first situation is when I'm actually executing the agreement. So that I can execute my agreement, I need to interact with my client or whoever my co-contractor is. Maybe it's not a client, maybe it's my provider, but I still need to interact with that person. Second situation is even before that, before you execute the agreement, you have to negotiate the agreement. Well, sometimes there is no negotiation, but in any case, you have to sign it. And I'm pretty sure you all know how a contract looks like. At the beginning, we describe who the parties are. And obviously, when we describe who the parties are, we're using personal data. So, again, you may be thinking, no, but I only do B2B agreements, so my co-contractors are companies, they're not individuals. Well, even then, when you describe a company in an agreement, you're going to have to say who is the legal representative of that company. You're not just, a company cannot sign anything. It's got to be an individual that's signing as a representative of such company. So there, whenever you're saying this company with a capital of blah blah blah, with a head offices at this address, represented by its president, Mr. Anderson. Well, there you go, Mr. Anderson. We just used the personal data. And I didn't think I was using any personal data, but I just did. And I didn't even sign my contract yet. I was just drafting it. Um, so, and of course, when you're negotiating the agreement, oftentimes you exchange some emails, perhaps some phone numbers. Again, a company doesn't have a voice and cannot type emails. Well, maybe now with artificial intelligence, maybe we're going to have some more automatic replies, but most of the time it's an individual that's typing an email. So whenever you're sending an email, you're sending it to someone, or whenever you're calling someone, you're calling an individual. So those are the first two example, two kind of situation. I'm executing the agreement and I'm using personal data, or I'm negotiating or signing my agreement, I'm still using personal data. We're going to get back to those examples, but I just want to lay out the different situations. Um, those two other situations are a little more tricky. Um, it's whenever there is a third party involved. So, for instance, I have an agreement with my client, but I am going to ask someone else to use the personal data of my client. It's my client, but I'm sending this personal data to someone else so that he uses the personal data of my client, but only under my instructions. And that I can do. For instance, well, here I think I gave the example in the other way around. So it goes the same way. I can be asked to use some personal data, even though I have no contractual relationship with uh, the the individual whose data I'm currently using. I have no relationship with that person, but someone else who has a relationship with that person asked me to use their data so that I do something. So, for instance, for the delivery of products, let's say that there is one company that's again selling some products online. So this company selling the products is the only one that has a contractual relationship with the client. But then they don't want to do the delivery of products themselves. They want to ask a different company to do it for them. So the delivery company is totally outside this contractual relationship with the client, but yet they're going to receive the data regarding the client so that they deliver the product at the address. Of course, they're doing it because they're making money out of it, but they don't get to do whatever they want with the data. In this scenario, they can only use the data pursuant to the instructions of the person who's responsible for the data. So here, the company actually selling the products. So again, we'll get back to that and we'll see what do we need to do in this context. And the last scenario is the kind of the I was going to say scariest of all, not really scary, but the worst of all, in that we really shouldn't be doing this. But if I decide in an agreement to just send out some data to someone else and not just like in the third scenario where it was just so that they could use under my instructions for a specific purpose. No, 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 no. Here, I'm transferring them some data and telling them basically, you can do whatever you want with it. Now it's your data. Well, we can see here how it's more problematic for the person whose data uh, it is. If I'm an individual and I entrust one company I entrust my data to one company, and then they just give it away, probably selling it to different companies. Well, again, there are some conditions that we can respect so that to make this lawful, but it is trickier. So we're going to see those different situations. So if I go back to the first scenario, um, just quickly going back on the fourth scenario that I described, um, those are the main situations. I'm not saying that there is no other situation that could happen that would imply the processing of personal data, but just making some big families of of things that could happen. So going back on the first one, when I'm executing an agreement and the execution of the agreement itself implies that I need to process some personal data. Um, so, like I told you, the first reflex that people have is uh, thinking whether let's say it's an agreement with a client. Maybe it also works for other type of commercial relationship, but let's say that it's a client. Oftentimes people are going to think, yes, if it's a physical client, like an actual customer, then yes, they can easily see that they are processing personal data. But again, it is very important to realize that even when it's not an individual, there are still some individuals that you're interacting with. For instance, if you have a B2B agreement, um, with you have a partnership agreement, let's say, and you're working jointly with another company to, I don't know, create a product together. I'm just saying anything, but it could be anything else, but just so that you have examples in mind. Yes, my co-contractor is not an individual, so the information relating to the company that I'm working with is not personal data. But whenever I'm interacting with this company, I'm writing emails to some people, I'm calling some people. So those people, they may be employees, they may be the partners of the company, they may be interns, they may be mandatory, they may be any kind of representative or any kind of agent. Um, Whatever their role is, they're acting on behalf of the company. um, but those are still people. Even when I'm exchanging with them, I'm doing so that I exchange with the company. They're still people. So what do I need to do whenever I am using the personal data of my clients, or so either of my client directly or of my client's employees or of my partner's employees, etc., or any kind of agent? When I'm saying employee, again, just think of the oldest list that I drafted here. um, well, the first question to ask yourself is always um, laying out all the different purposes for which you need to use some personal data. And for each of those purposes, you need to find an applicable legal basis. So we're going to see this just right after. What is a legal basis? There are only 6 of them, so it's pretty easy to determine which one is applicable. But you should always bear in mind that whenever you're processing any kind of personal data, it should always be based on one of those 6 legal bases. This ensures that your processing of personal data is um, lawful. And whenever you're in the context of a contract, don't worry, because there's almost always a legal basis that applies. And if there aren't any legal basis that apply, well, there's still one legal basis that we can always use. It's consent. If you get consent, then you can do whatever you want. But it has to be a valid consent. And that's a little trickier, but we'll see that right after as well. And the other thing I need to do is to inform the data subjects. So it's one thing for me to know what I'm doing, to know that, okay, I'm going to process some data, but it's okay. I'm allowed to process this data because it's for the execution of a contract, or it's for legal obligation, or it's because I have consent, or whatever. We'll see those legal bases after. But I know that what I'm doing is lawful, but I also need to inform the data subjects of what I'm doing. So basically, anytime that I'm signing a contract with any kind of person, whether this person is physical or an entity, I need to inform them, hey, by the way, when we're executing this agreement, I'm going to have to use some personal data. Either your personal data directly if you're an individual, or I could also use the personal data of your employees, of your representatives, etc., if you're an entity. So I'm signing a contract in B2B with a company. I have to inform that company, by the way, when we're going to execute this agreement, I'm going to have to use the personal data of your employees just so that I send them some emails and stuff so that we can interact. It may not seem like a big deal, but if I'm using personal data, I need to do this. I need to inform the data subject. So whenever it's I'm contracting with an entity, I'm not going to be responsible to reach out to every employees of my co-contracting entity. I'm just going to tell my co-contractor that this is what I'm going to do with the data of your employees, and you're responsible to tell them what I'm doing um, with their personal data. So see, this happens almost anytime. I see very few commercial relationship when you're not going to send any email or give any phone call. It's almost impossible. So you still have some things to do. I'm explaining the second scenario right away because what you need to do is pretty much the same thing, and then we'll go back to what is a legal basis and how do you inform the people. So the second scenario, like I said, is when you're before executing the agreement, when you're negotiating the agreement and signing the agreement. So, like I said, even when during the execution of the agreement, there is no kind of interaction whatsoever with the co-contractor, which is almost impossible. But let's say it's the case. I have an agreement, and once I have an agreement, I'm not going to send you any email or anything. Okay. Well, even then, when I signed the agreement, I wrote down the information of someone who signed that contract. Like I said, if my co-contractor is an individual, then then it's easy. The information of my co-contracting party is personal data. But even when it's an entity, then I'm always going to have to write down at least the name of a representative who is going to sign the contract. And of course, when I'm negotiating the contract, even if it's not a big negotiation, it's just like I'm sending you a draft of my contract and you're signing it and you're sending it back to me. Well, I had to send it to someone. So again, this someone was probably an employee or a legal representative of the company or anything. And in that case, I used an email address. And I may have also used the name of the person I was sending the email to. Probably. So again, here it's going to be the same thing. I'm going to identify exactly all the reasons why I'm going to use personal data. And here you really need to think big again, always think as broad as possible. For instance, it's not enough to say, I'm processing personal data with when my clients place an order. Sure, when they place the order, I'm going to process some kind of personal data. But then there is also the delivery that's going to imply different things. There's also the payment. There's also invoicing. There's also the when I'm conserving the invoices from my personal records. There's also going to be any exchange that I may receive after sale if there is any kind of issue with the products that I just delivered. So all those are different purposes, and for each of those purposes, I need to find what is the applicable legal basis to make sure that I'm allowed to process information for that reason. So you probably imagine that, okay, for delivering the product, I'm allowed to process personal data. Sure. What about if I want to use that same address to send them a commercial flyer? Can I do that? Maybe yes, maybe no. But to make sure that I can do it, I need to find the applicable legal basis. And once I've identified what I'm doing and making sure that what I'm doing is lawful, then I also need to inform the data subjects. So now we're going to look more deeply into this legal basis and information of the data subjects. And then after, we'll move on to the third and fourth scenario. So legal basis, like I said, there are only 6 of them. And the 2 last ones that I wrote down here, we almost never use them. In particular, we almost never use them in a contractual relationship. Like, I'm going to be allowed to process personal data for if if I'm doing a public interest mission, but then we wouldn't be in the context of a commercial agreement, or to protect the vital interest of someone. But then again, I wouldn't have a contractual obligation to do so. So those 2, first of all, we rarely use them, and also they're kind of outside the scope of commercial agreements. So I'm setting those 2 aside. But if I'm looking at the first 4 one, like I said, consent is just one of the legal bases, and it's kind of the last one that I'm using. People always think, ever since GDPR entered into force, people think, oh my God, we always need consent for everything. It's driving me crazy. No, that's not true. Almost all of the data processing that is carried on is without consent. Basically, it's only when none of the other legal basis apply that then I need consent. Because it means basically you shouldn't be processing personal data. But if you still want to do so, then you're going to have consent. But most of the time, there's a perfectly legitimate reason to process personal data. We're not just processing personal data for no reason. So, what are those reasons? First, uh, contractual execution, like the execution of a contractual obligation. So, this is basically what we were just discussing. So, whenever my contractual obligations require me, and I insist on require, whenever it requires me to process personal data, then I can do so on the legal basis of contractual execution. So basically, if anyone is buying a pair of shoes online, uh, to me, I'm the company selling the pair of shoes. Well, once they've placed their order, I have the contractual obligations to deliver that pair of shoes. So I'm not going to ask, oh, by the way, do you consent to the processing of your personal data? Because if I do so and they say, no, I do not consent to the processing of my personal data, how do I do to deliver the pair of shoes? It's impossible to deliver the pair of shoes without using that person's name and address. It's impossible. So it wouldn't make sense in this context to ask for consent. Here, I'm just going to say, okay, we agreed on a contract. So that I can perform my obligations, I need to process your personal data. Therefore, I'm just doing it on that legal basis. And that legal basis also includes all pre-contractual measures. So that includes my scenario number 2, where we were negotiating an agreement. For instance, we want to enter into a partnership agreement, but we're still discussing it. And so we're using each other's personal data. We're sending some emails, we're placing some phone calls. So we're using personal data, and we haven't entered into any agreements yet. So it wouldn't be correct to say that I have a contractual obligations to use this personal data at this point, but it is for the purpose of signing an agreement. So even if we don't sign the agreement, when we were exchanging and using each other's personal data, it was for the purpose of maybe entering into an agreement. So that's still okay. Any kind of contractual measure would be fine. There is another set of obligation. It's legal obligations. Sometimes It's not specifically written in the agreement that I need to do anything, but I still have an obligation by law to do something. So that would be, for instance, I don't know if it's exactly the same duration in other countries, but for instance, in France, we have a legal obligation to keep any invoices for 10 years. We don't have a choice. We have to, so that we can show our good accountancy. So even if my clients is not happy about it and is saying, I don't want you to keep my name anywhere anymore, I'm going to say, okay, I'm going to delete all your information, but I'm still going to keep that specific piece of information, just your invoice, because I have a legal obligation to do so. And I'm not arguing with law. If I have a legal obligation to do anything, and that implies the processing of personal data, I'm still doing it, whether you're happy or not. Um, Legal obligation is really strong because, but there's nothing to argue, basically. That also applies, for instance, if I have a court order or a police order to do something, for instance, to transfer some data. If they're asking me to provide some data about I don't know, one of my clients, well, if I have a court order to do something, I'm not going to not comply by it. I'm just listening to whatever the state wants from me, basically. Um, so sometimes, again, in contractual relationship, it may imply some legal obligations that will lead to data processing. And then there's also lots of processing that we do on the basis of legitimate interest. This one is a little harder to understand because it needs to be balanced with the rights and freedoms of the data subject. What does that mean? Basically, if I want to process personal data, most likely it's that I have an interest to do so. I'm not just doing it because it makes me happy. I want to do it because I have an interest to do so. Maybe the interest is simply to promote my products or services, for instance. Like, I want to send you a promotional email. So I'm using personal data. My interest, I want to promote my products. But then the recipient, maybe the recipient didn't ask for anything. He didn't want to receive a promotional email. So how do you balance that? Well, basically, you need to follow the guidelines of your data supervisory authority. So what I'm saying here really again applies to France. It is similar in most EU country, but still there are some differences. But for instance, for existing clients, if I already sold a product or a service to this one specific client, then I'm allowed to send this client some marketing information, because I can presume that this client will be interested in receiving such information because they already purchased something from me. And so they already showed an interest for what I was doing. I can only do that for 3 years after they placed their last order or after we last interacted together. After those 3 years where this client showed no further sign of interest for my products, then I need to stop sending those promotional emails. Or if I want to do so, I'm going to have to get consent. And so that this is valid, you always need to use the opt-out link at the bottom of the email. So basically, I'm presuming that you will be interested in what I'm sending you, but if you're not, you can just in one click say that you no longer want to receive this kind of information. So it makes it kind of okay if we balance the rights and freedoms of the data subject and the interests of the company, basically it's not too invasive for this person, because they can opt out at any time, and they're only receiving this because the company already had the information about them, and we could easily presume that they were kind of interested about those products and services. And again, if they're not, they can just opt out. It would be very different if I wanted to send a promotional email to someone who has never showed any interest about my products or services. I would still have an interest in promoting my products. It would be an even stronger interest because I want to get new clients, but it wouldn't be fair to just send out some email to random people. Let's say, for instance, right now I'm giving this lecture, and supposing that I have your email address, and I'm just gathering this information and thinking, hey, actually, on in my free time, I created this new line of handbags. And I'm pretty sure that those students are very interested in my handbags, even though you've never said anything about my handbags. You're only here to listen to me talk about contractual agreements, commercial agreements, I'm sorry, and data protection. That's it. You have no interest in my free line of handbags. So if I used your email address to send some promotional information about my handbags, well, I would have an interest to do so, to promote my products, but it wouldn't be legitimate because it would outpass your rights and freedom. It would be too invasive. If we take an easier example, let's say that I have a website with my contact information on it, and people can reach out to me. I don't have any contractual relationship with the people who reach out to me, but I have a legitimate interest in receiving this information and in responding to those people who reached out to me, even though maybe there's not going to be any contractual agreement that will be signed, but I would still have a legitimate interest um, to process this information. So, anyway, this is just so that you understand that whenever I do anything with personal data, there has to be a lawful reason for such processing. So usually we're going to try to use contractual execution, legal obligation, and legitimate interest. And if none of those three apply, then I'm going to use consent. But here I want you to be cautious because you're probably thinking, here we are thinking about data protection in commercial agreements. So the only legal basis we're going to use is contractual execution. And that's not true. Even when you have an agreement, some of the data that you're processing will be based on contractual execution because you actually need to process the information to comply with your contractual obligations. But sometimes you're also going to process information of your co-contractor for other reasons, like for a legitimate interest, if you want to send a promotional email, or for a legal obligation or anything. So whenever you're signing a contract, you're going to have to use all of those legal bases. Not necessarily all of them, but you have to consider them all. Um, just a quick note also on sensitive data. Um, Everything that I was saying before applies to regular data. For regular data, all you need to do is find one of those applicable legal bases. If you've done so, then you can process personal data. That is not the case for sensitive data. For sensitive data, the rule is that any kind of processing is forbidden, except in some very, very specific cases. So, what would be what would be sensitive data? Lots of people think, for instance, that bank information is a sensitive data because it relates to your money and you don't want to be stolen anything. Well, of course, bank information is going to be a kind of data that requires specific protection, but it's not what we mean by sensitive data. Because even if bank information requires a specific protection, we're still using it all the time. Anytime you make a payment online, the company is processing your personal data. And again, it doesn't mean that they're storing your credit card number, but still they're using it to get payment. So your credit card number is being processed so that you make a purchase. So it wouldn't be fair to say that it's sensitive data, because we're not supposed to process sensitive data at all. So don't confuse the data that needs to be protected and sensitive data that just simply should not be processed. So the kind of data that simply should not be processed is basically anything that's discriminatory. If I make a broad generation, like anything that's related to racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, um, also anything that's related to sex life or sexual orientation. This would be anything that's discriminatory. You can also add to that all the data that identifies someone so uniquely that it makes this information too dangerous, such as genetic data and biometric data. Um, for example, my fingerprint, that is a sensitive data that usually a company should never ask me my fingerprint for anything. Um, and you also have health data. And there you're probably thinking, but health data, I can recall a number of times that I've been asked information about my health. Well, it's still a sensitive data, but it may apply to some exceptions. So again, the rule is really never ever process any sensitive data. So especially if you're in the context of a commercial agreement, processing any of these sensitive data is usually a bad idea. Again, except if you fit into one of those exceptions, but they're very, very specific. So if it's to protect someone's vital interest, then you can process personal data, in particular, obviously, health data. If you're a member of a religious or political organization, obviously, this organization is going to know about your opinions. Like, for instance, if I reach out to a political party and tell them that I want to subscribe, I want to be a member, well, then they're going to know that I'm sympathetic to their political beliefs. So they're processing sensitive data about me. They know my political opinions. But I mean, there's really no other way around it. So it's okay for the members of those organizations to know that I also share the same opinion as them. Also, whenever data, the sensitive data is made public spontaneously and manifestly by the data subject himself or herself. For instance, if I'm negotiating an agreement with a co-contracting party and I'm just sharing spontaneously that my political opinions are such or such. Well, it doesn't mean that they should keep this information and do anything with it, but the simple fact that they knew this information, they've already processed it. You can't unknow something that you've known at some point. So again, recording this information would be wrong in this context, but there is an exception for just knowing the information that was made public by the data subject. Also, sometimes on the basis of public interest, we can process personal data, but public interest itself is not sufficient Many times, especially during the COVID pandemic, there were instances where some organization just wanted to collect some health data on in the name of public interest, just saying yes, but we need to stop the pandemic. It's in the general interest of everyone to stop this thing from happening, so we are going to be very invasive and ask you personal question about your health. Well, no, you can't just decide that's you can't decide yourself what is in the name of public interest, so you would need to get an authorization from the supervisory authority. So in France, it's CNIL, Commission Nationale Informatique et Liberté, but then there's a different authority in every country. So you would need to get a specific authorization. And again, if you get consent, then if you get consent, you can do whatever you want, but consent has to be valid, and that's not easy. So how do you get a valid consent? Um, First of all, you need to keep record of when you of the fact that you obtained consent and of when you obtain it. You must be able to show some proof. So if, for instance, it's an electronic box to tick, well, you need to have some kind of system that records every time that someone clicked the box, so that you can show, look, this person consented at this on this day at this time, and this is why I'm doing this processing on the basis of consent. And also, it should be free. So that means, of course, that it shouldn't be forced, but also it shouldn't be influenced. Usually, it's supposed to be a complete choice. You should never try to trick the data subject into accepting the processing of personal data. If you're making some kind of strategy and thinking, if they have to tick this box so that they go on and move on to the next step, etc., you're probably doing it wrong. So for general terms and conditions, you can do that. For instance, you can't place a purchase if you do not accept the general conditions. That's all right. But then if you also want to get consent, for instance, to send a newsletter or anything, and that the data subject cannot place its order if he doesn't tick the box to consent to receiving a newsletter, that is not all right. That's just not okay. The person needs to want to receive the information. And in many cases, it can be the case. For instance, if you want to get some promotional information from our partners, well, maybe I love shopping online, and I would be thrilled to get some more promotional discount codes, even if it's from a different um, company. Then yes, sure, I consent. I want to get some discounts, but maybe I don't care about having discounts and I don't want to receive emails. In that case, I'm not taking the box. Um, it also means that I need to be properly informed of exactly what I'm consenting to and how my data is going to be processed. The consent also has to be specific. That means that I'm consenting for one type of processing, only one purpose. And if you want to request consent for several things, then you need to request for several consent. For instance, if you have a box, then you must have several boxes so that I can consent to one thing, but maybe not to the other one. And then it needs to be unambiguous. So, for instance, if I'm using a box again, it shouldn't be pre-checked. It has to be a positive action from the person. Like, yes, I want to receive some information. I'm ticking. That means I consent. If it's already ticked and I just wasn't careful, and then you imply that I consented to anything just because the box was already ticked, it's not valid. Also, no group consent. For instance, you can't have one box for I agree to the terms and condition of purchase, and I consent to the processing of my personal data for this or that reason. That doesn't work. This would be two separate boxes. And it's not just I consent to the processing of my personal data. You need to specify what kind of processing. I consent to what exactly. So, like I said, no consent in case of inaction. It has to be opt-in. It has to be a positive action. So all of this was the lawful basis for my processing. And again, like I told you, the other thing you need to do all the time is to inform the people. And that's you do with a privacy policy. So usually what I do, remember the two first scenario that we've discussed, when I'm signing an agreement and then when I'm executing this agreement, I almost always have to process personal data. Therefore, in appendix to my commercial agreements, I always have a privacy policy just to inform, hey, I'm signing a contract with you and I'm going to use some of your data or some data of your employees. So here's what I'm going to do. There should always be a privacy policy attached with a commercial agreement. So it's very strange that lots of people do some commercial agreement without this um, data protection consideration. So again, the purpose of this privacy policy is to inform the data subject of what you're doing. So basically, the first thing is who you are. I'm this entity. Sometimes it's not clear. Sometimes people know the name of a brand, but not the name of the company behind the brand. You need to make it clear. It's this company that is processing your data, and maybe I'm also going to send your data to some of my subcontractors, for instance. I'm saying who are the people who are going to know your data, and then you're describing what you're doing. So all the reasons why I'm using personal data. So remember what I told you before. You need to subdivide, like when you're placing an order, I'm processing your data. When I'm delivering the product, I'm processing the data. When I'm processing your payments, I'm processing some data. And for each of those purposes, I need to determine what is the applicable legal basis. So for the three ones I just said, it would be execution of an agreement. But then if it's sending a promotional email, this is not required to execute the agreement. So it would have to be either legitimate interest or consent. So for each reason, what is the applicable legal basis? What sort of data am I collecting? And this is also why we need to subdivide. For instance, when you're placing your order, I don't really need your phone number. I just need your name, your email address, so that I can follow up with this order. But then for delivery, most likely I need your phone number so that I can, once I'm at your door, I can call you and be like, hi, I'm here. I can't find the bell. Can you get down? And so that I can deliver the package. So for each purpose, you detail fully all the data that you're collecting, and you should never say etc. Not etc. The people is not interested in knowing pretty much what you're using of information regarding them. They want to know exactly what information that you're going to use. And then who does this data relates to? So it relates to my clients or to the employees of my co-contractor or to my employees, maybe. Anyway, who does it relate to? And how long am I going to keep it? And what am I going to do with it? So for each type of reason that makes you process personal data, you have to describe all of this. And then you also have to explain where you're storing personal data and what sorts of security measures are you implementing so that people know whether it's safe or not to entrust you with their personal data. And then you have to detail the rights of data subjects. Once you've explained what you're doing, you also have to tell them, by the way, you have some rights. Here are all the things that you can do and how you can exercise those rights. And the rights, they are the right of getting some information, accessing your personal data, just knowing, just give me all of the data that you're processing about me. Right of rectification, if there is an error at some point, erasure, limitation, and right to object. So erasure, it's like when the company has the data regarding me and I want them to erase it. Limitation, it means you can have my data, but only use it for some specific reason. And then the right to object is I do not want you to get my data. So why did I write in certain conditions for those three? Well, because it depends for what legal, on what legal basis I'm founding this processing. If it was just a legitimate interest, then yes, people can say, hey, yes, you're saying that you have a legitimate interest to send me some promotional emails, but no, I do not want to receive this information. So stop processing my data for this reason. On the other hand, if it's for a legal obligation, I'm not going to ask them their choice. So if they want to say, hey, you have to delete my data, but I have an obligation to keep the data, I'm keeping it if I have an obligation to do so. So those rights only in certain conditions. Then data portability, that means that I can request a company to send the data regarding me to another entity. You also have the right to withdraw consent, of course, only when the processing was based on consent. And then you have to know also that even those are all the GDPR rights that apply in all of European Union. Some rights, some countries have additional rights. For instance, in France, we have this one specific extra rights for data subject is the right to set post-mortem instructions. That means that you can determine with a company, hey, once I die, I want you to delete my data, or I want you to keep them, or I want you to do whatever with my data, or I am designating this person to say what you should do with my data. You can set some instructions. That is a French specificity. I'm not saying it doesn't exist anywhere else, but not to my knowledge. And of course, you also have the right to introduce a complaint with a data supervisory authority. And there's some strict timeline to answer to all those requests. It's usually 1 month. But if it's the request takes a long time, for instance, to gather all the information that you have about one data subject, sometimes it can take some time. And so you can answer within 1 month and say, I'm going to need an extra 2 months. So in total, you can have 3 months, but you still have to answer within 1 month and say that you need this extra time period. Going back on my scenarios, remember how we talked about processing under the instruction of someone else. So this is a very important point as well in commercial agreement, and it happens way more often than we think of. Anytime, most of the time, anytime that you're transferring data to another party, most of the time it's data processing, and it means that you need to sign a data processing agreement. That means that I'm sending some personal data. I'm responsible for the data of my clients, but I'm deciding to sending this data to the delivery company so that they can deliver my products. So I'm responsible for the data of my clients, but I'm sending it to someone else. But I'm allowed to do that because basically, as long as I'm doing it for one of the purposes that I identified with my client. My client, I told him, I'm going to process your data for this and this and that reason. And one of those reasons was the delivery of your products. And then I'm choosing to process the data for delivering the product with someone else because I cannot do everything myself. So the delivery company is going to be allowed to process the data to take care of the delivery. But since they're only data processor in this context, they cannot use the personal data for their own purposes. They cannot decide what to do with the data that I gave them. I'm the data controller. I'm the one who decides what to do with the data of my client. So if I'm sending this data to the delivery company, they can only do what I say. So in this context, the first you should identify why what is the purpose of behind the transfer. So in my example, it's the delivery of the products, for instance. And the thing that's going to be most important is determining who is data controller and who is data processor. In my example of delivery, it's quite easy, but sometimes it's not that easy. Sometimes the person who's collecting the data is actually only processor and then sending it to the controller because he was instructed to collect this data. So you should always try to think who decides of the instructions. And so, like I said, what you need to do is draft a data processing agreement. Again, everything that I'm saying is regarding GDPR. So I don't know the equivalent of any any legislation in the entire world, but most likely there is something similar. Um, and of course, you also need to inform the data subjects that you may transfer their data for delivery purposes. You don't necessarily need to indicate precisely who are all the companies that you're going to use, but you just simply need to inform them. For some of the purposes that I've identified, I'm going to use some external companies, so don't be surprised that they have your data. How do you identify who is the data controller and who is the data processor? Well, you always need to go back to who is determining why we're processing data. The person who's determining the purposes of the data processing is the one who is the data controller, and also determining the means of the data processing, like why am I processing data and how are we going to process data. The person who decides this is responsible. And then the data processor is the one that answers to the instructions of the data controller. So, like I said, the data processor can only process data under the instruction and not for the reasons that he determined. And also, in this context, I'm the data controller. He can send data to the data processor without necessarily providing any extra information to the data subject because he already informed the data subject, I'm going to process your data for this reason. It's not for a new reason, it's for a reason that already existed. So basically, I told my client, I need to process your data for the delivery of the products, and then I'm deciding to transferring it to a different company so that they take care of the delivery. So whenever we have this kind of relationship, and it is very often, we need to sign a data processing agreement. When I'm saying it's very often, for instance, I'm a lawyer. I'm the data controller for all the clients, all the data of my clients. But for instance, I'm sending all my invoices to my accountant, who's external to. I'm just me, so I don't have an entity. My accountant is external. So whenever I'm sending my invoices to my accountant, he's my processor. So he can use this data, but only under my instructions, only to process my invoices. And he's not going to get, for instance, to use the data of my clients to reach out to them and ask them if they want some accountant services. That's not okay. So basically, the role of this agreement is to determine what are the instructions. So what does the processor need to do? And specifically, how? What exactly does the processor have to do? and also the respective obligations of the controller and the processor. So, for instance, if one of the data subjects wants to exercise its rights, um, like the right of rectification, who needs to answer to the data subject? Is it the controller or the processor? Well, it could be one or the other, but we need to set this out in the data processing agreement. So basically, there are no questions when the problem arises. We know who's responsible to doing what, and the processor exactly knows what he's allowed to do and what he must do also, for instance, implementing security measures. Because if he gets a data breach, the data controller is also responsible, and then he needs to establish that he required the processor to implement such security measures, and it's not his fault that the processor did not do such measures. So this is also a document that is very often in appendix to commercial agreements. Those are the most two common appendix that you are going to find in commercial agreements. The first one that I described was the privacy policy, to explain to the people, hey, we are signing an agreement together, and in the execution of this agreement, I'm going to use some data of yourself or your employees. I'm sorry. Just information. This is what I'm going to do with your data. And the second document that we just discussed, the data processing agreement, it means, hey, we're signing this agreement together, and in the things that I'm asking you to do for me, you're going to have to process some data that I'm controlling, and you're going to have to do this exactly in this manner. You're not going to have to do. So usually, typically, it's the data controller who should be drafting the data processing agreement and setting out instructions for the data processor. But oftentimes, it's reversed, especially when you're signing an agreement with a very, very big company who is going to be your processor. For instance, um, I have my data. My data is hosted on Microsoft, a Microsoft server. So I have an agreement with Microsoft to host my data. So they are the data processor, and I am the data controller because it's the data of my clients. So I'm the one controlling it, and I'm the one instructing Microsoft to host my data. But obviously, I'm not going to get to negotiate with Microsoft. They have their standard agreement, and they are going to make me sign this agreement. But their agreement includes a data processing agreement so that I don't have any concerns. And I know that, sure, I'm entrusting you with the data, but we're doing it in a manner that's compliant with GDPR. So it's all fine. Oh, yeah. And I just wanted to do a quick note on, because I was saying all of this is only when GDPR is applicable. So theoretically, it's applicable everywhere in the EU, and actually also in a few countries that are not technically in EU, but also agreed to comply with specific legislation such as GDPR. For instance, Iceland is not part of the EU, but they still comply with GDPR. But just bear in mind that entities, even when they're outside the EU, they should still comply with GDPR if they're offering goods or services to consumers located in the EU, or if they're monitoring behaviors of individuals located in the EU. So, for instance, what I just said, Microsoft, it's an American company. We all know that. But they're offering services to consumers located in the EU, like me. And so when they're signing an agreement with me, they need to comply with GDPR. So that's what we call the extraterritorial effect of GDPR. That was a quick parenthesis. And we're going to finish with our fourth scenario, the one that technically we should not be doing. Basically, this this is the very example of what my client think I'm talking about when I'm talking about data protection. And they're always answering, oh, no, 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 but don't worry, I'm not selling the data to anyone. I'm not transferring it to anyone. And I'm telling them, hey, even when you're not doing that, you're still doing a lot of things with data, all the things that we just discussed. But some people are still doing this. Some people are transferring data to people who to a third party without any particular instructions, just basically, hey, let's share our client database, for instance. So theoretically, you don't have any legal basis to do that. So, for instance, if I have data from my clients, and like I said, I'm allowed to transfer it to a third party if it's to fulfill the purposes that I determined. That was the data processing agreement. Um, but if I'm sending it to a third party, not for one of my purposes, but for the purposes of that third party, basically, that third party wants the data of my clients so that they can do whatever, probably send them some promotional emails. That's a data transfer, simply. And in that case, we can only transfer the data if we have consent, because we don't have any other applicable legal basis. So in that case, what you're drafting is not a data processing agreement, but a data transfer agreement. Basically, you're going to detail to the person that you're transferring the data, I'm sending you this data because I got consent, and you explain what consent exactly you got. And of course, um, remember that consent can always be withdrawn, but this kind of transfer is more dangerous, and even more dangerous obviously when it comes from the EU and it goes outside the European Economic Area. In that case, there is a specific kind of agreement. When it goes from the EU to outside the EU, there's a specific data transfer agreement that was set out by the European Commission, and it's a very difficult agreement that basically no one ever wants to draft. So my advice, obviously, is to avoid this kind of scenario. Um, Sometimes you need to do a data transfer agreement outside the European Economic Area, simply because it was a data processing agreement and your processor just happens to be outside Europe. But that's a different case. If I'm just sending to a third party for no reason at all, well, don't do it unless you get consent. And I'm pretty sure that this was all I had. And I think I'm almost reaching out the very, very end of my timing. So I'm sorry. I was hoping to get a little more time to answer some questions. I don't know if there's one or two questions, maybe. Maybe I should stop this. And I don't know if I'm supposed to hear anything, but I'm not hearing anything. So I'm going to assume that this is over.
Thank you so much, ma'am. As you mentioned, like, yeah, if you don't mind, can we open the floor for questions now?
Yes, that's just what I was saying, but I'm not receiving any questions. So I don't know if that's normal or not.
So, ma'am, these questions are usually put in the comments. So, if anybody has any questions, please put them in the comments. think we have any questions for now. So if you don't mind, can we end the session?
Yes, that's fine. I
Yeah.
hope everything
Uh,
was clear, and thank you again for having me in this lecture.
Thank you so much, ma'am. Before we end, I would also like to just thank you for taking your time out and contributing to this project. This was an extremely insightful session. Thank you so much.
Thank you. Bye.